morning, Madam Registrar. Could you open the proceedings?
Caribbean Court of Justice, Original Jurisdiction. Hearing of the matter, St. Lucia and Grenada against Trinidad and Tobago. The members of the panel are Mr. Justice Witt, presiding judge, Mr. Justice Anderson, and Madam Justice Rajnath Lee. May we have the appearances, please?
Good morning, Your Honors. My name is Celine Ducran and I am Senior Counsel for the States of St. Lucia and Grenada. I am here today with my junior counsel, Mr. Dylan Kalu, and we are ably instructed by Mr. Ronaldo Ramjohn. If it pleases this honorable court, I will now begin my submissions.
Yes, that's all right. The defendant state has not appeared. I'm not sure why. Maybe a lost file or something. But we will, of course, we have enough of the written material, so to see what you will bring and see if you tackle all the issues that are relevant. So you can start.
Your Honors, the case before us today deals with a state breaching their international obligations and subsequently diminishing the effect of community law. Trinidad and Tobago has enacted Section 15(1)A of the Legal Profession Act, which creates an alternative pathway to practice law in Trinidad and Tobago. However, the enactment of this legislation is only exclusive to Trinidad and Tobago nationals, thereby excluding all other CARICOM nationals.
Can you say when that amendment was enacted? What year, can you say, just off the cuff?
2000, I believe.
2000, yes. Okay, thanks.
We will be submitting today that Trinidad and Tobago has breached Article 7 of the revised Treaty of Chaguaramas, as well as a breach of the agreement establishing the Council of Legal Education. Trinidad and Tobago has breached their international obligations because two factors are satisfied. The first being is that there is a law that conflicts with the state's international obligations, and the second being that when this law is applied in practice, it is prejudicial. My first argument will consist of two sub-issues. The first sub-issue is that Trinidad and Tobago has breached the principle of customary international law, and the second sub-issue is that community law should take precedence over domestic law.
Yes, but before you go there, and I apologize for interrupting you again, just to get the on the bush cleared, you say that Trinidad and Tobago incorporated the Council for Legal Education Agreement into its domestic law, and then it passed an amendment in 2000. When did it, if you know offhand, when did it incorporated the CLE agreement? Do you happen to know?
I am unclear as to that, but I believe that my junior counsel will further elaborate on the amendments relating to the Council of Legal Education. Okay,
and then you mentioned subsequently that Trinidad and Tobago incorporated basically, let us say, RTC legislation to do with the CSME and so on. Do you have any idea of the dates when that might have been done?
Can you repeat the question, please?
Yes, I think you indicated that Trinidad and Tobago also incorporated legislation to give effect to its obligations under the RTC, the CSME arrangements. And I was just asking, do you happen to know when Trinidad and Tobago did that?
I am not sure as to the date of when specifically that was enacted, but we do acknowledge that Trinidad and Tobago has enacted in their domestic legislation to give effect to the RTC.
Yes, and do you know whether it was before or after 2000?
It was after 2000.
It was after 2000?
Yes.
Yeah. Okay.
So the RTC does take precedent in terms of time. It came after the Council of Legal Education.
Wonderful. Thank you so much.
Please continue.
The revised Treaty of Chagramas is a source of international law and must therefore be adhered. Article 7 of the revised Treaty of Chagramas prohibits discrimination on the grounds of nationality. In addition to this, there are other sources of international law that prohibit such discrimination. For example, Article 14 of the European Convention on Human Rights prohibits discrimination of all types. This definition is therefore wide enough to include nationality. Additionally, Article 18 on the Treaty of the Functioning of the European Union also prohibits discrimination on the grounds of nationality. This is relevant in this case because the TFEU has similar aims and objectives as that of the RTC, being that it seeks to promote movement as well as equality and fairness between members of nationals of their member states. Additionally, this also repeats the rule of customary international law. By the prohibition of discrimination being enacted in such treaties, this shows us that this is a pertinent rule of customary international law. So Trinidad and Tobago is not only breaching Article 7 of the RTC, but they are also breaching customary international law. Article 12 of the draft articles of the ILC also repeats this very important rule of customary international law, that a state is breaching their state obligations where there is a law that conflicts with such treaty obligations. Article 4 of this also goes on to state that an act of the legislature also constitutes an act of the state. Therefore, by the enactment of such legislation by the legislature, Trinidad is not only breaching Article 7, but they are breaching customary international law as it reads relating to the draft articles of the ILC.
Yes, we may come back to this, but I just wanted to get clear your statement that the act of the legislature is regarded as an act of Trinidad and Tobago.
Yes.
And you're, okay, wonderful, fine, thanks.
But you're not only saying, I think, that the fact that you have this legislation, that alone doesn't constitute the breach. I think you're saying not only do they have the law, but they apply the law.
Yes, Your Honor. That brings me to my second point, which is Trinidad and Tobago's state practice has proven to be discriminatory. And this was seen in the case of Maurice Tomlinson, which deals with a Jamaican homosexual male who was prevented entry into Trinidad and Tobago as well as Belize based on their national laws.
Was not prevented,
Yes, he was not prevented, but...
So if you look at the legislation, he might have.
Can you repeat the question?
Although when you look at the legislation, he might have been prevented to enter, but they didn't prevent it. So that, so that is the point of, you know, that's what the court said. Okay, well, you have this legislation, but in fact, you are nevertheless not applying it. And that is the point. If you apply legislation which is in breach of
Yes,
your international obligations, yeah, then we have to do something.
We submit that in this instance, we want to contrast the case of Maurice Tomlinson with this particular situation, because Trinidad and Tobago's state practice has shown that it is not in conformity with their state obligations. In fact, by rejecting Mrs. Khalid, in addition to potential other CARICOM nationals who wish to practice in Trinidad and Tobago, this is showing that their state practice is discriminatory in nature and a breach of Article 7 of the RTC. Because as this court held in Maurice Tomlinson, the mere existence of national laws is not enough to amount to discriminatory behavior. So, therefore, in this instance, Trinidad and Tobago's state practice has been a breach of Article 7 by directly rejecting a CARICOM national who is not a Trinidad and Tobago national.
So you're saying, ma'am, that both limbs have been satisfied then?
Yes.
There is the legislation and it is being practiced by Trinidad and Tobago. Is that what you're saying?
Yes, that is what we are arguing and submitting today.
Okay, so now can you go a little bit into, you're saying, well, this is discrimination on the basis of nationality only. What kind of, how do you decide that, that this is discrimination?
This is discrimination because a Trinidad and Tobago national who seeks to use this alternative pathway to be able to practice, if we compare this to any other CARICOM national who has the exact same qualifications as that Trinidad and Tobago national, we see that the only difference from being able to admit it to practice is the fact that this CARICOM national is not a Trinidad and Tobago national. They can have the exact same qualifications, but the mere fact alone of them not being a Trinidad and Tobago national is what we base to be discrimination.
Now, Article 7 also speaks about within the scope of this treaty. It cannot be just anything. The discrimination must fall into the scope, within the scope of the treaty. So, could you explain why this is so in this particular case?
Trinidad has brought up the defense of using Article 30, subsection 2, as well as 30, subsection 3, saying that Article 15.1a has invoked the protection under this particular section because it is part of their exercise of governmental authority. However, we are submitting that the exercise of this governmental authority has not been extended to producing a scheme of legal education. It does not fall within the 4 categories listed under Article 30, subsection 3. Therefore,
ma'am, before you reach though to 33, won't you have to show us a link between Article 7 and the Chapter 3 rights? Have you put into your written submissions any of those Chapter 3 rights? Just assist me, please.
we have not put those submissions into our Chapter 3 rights, but we recognize that there are 4 substantial Chapter 3 rights, which is the freedom of movement of community nationals, which is the most relevant in this case.
You mean Article 46?
Article 46 does talk about the freedom of movement, but we recognize...
And the right to seek employment. Huh?
Yes, and the right to seek employment. And under Article 46, one of the categories are university graduates. So given that Mrs. Khalid has obtained an LLB as well as an LPC, she is clearly recognized as a university graduate and can therefore deem to fall within the scope of this article.
But what if she would want to establish her own chambers? Then she wouldn't, well, technically seeking employment, but just to have her business here. Do you recognize that?
Yes, we do recognize that. We do recognize on a whole... Sorry, Anna.
No, I didn't say anything.
Sorry. Sorry. So we do recognize that Mrs. Khalid has not been given, well, she has not worked for an LEC, which means that she cannot be able to practice in member states who have been signatories to the CLE. But what we are trying to argue here is that the bigger and wider issue is that Trinidad and Tobago has breached their international obligations. And this is not only affecting St. Lucia and Grenada, but it can also affect the wider CARICOM region.
Okay.
Yes, but I wanted to follow up on what my sister asked you, because she was trying to, as I am myself, trying to find the link between your argument that Article 7 has been breached and what substantive rights you say have simultaneously been breached. I think we all agree that we can't just plead a breach of Article 7 in the abstract, because Article 7 doesn't stand alone. So we have to find the right, which in your case you say would have been breached, and breached by discriminatory treatment. So I think again in response to the bench, you mentioned that you understood that certain rights are in fact affected by the actions of Trinidad and Tobago. But the question I think that my sister asked is, do you point to any of these rights in your skeleton argument? Because clearly we would be helped, I think, somewhat if you had indicated in response to the chair, I think you discussed Article 46, for example, freedom of movement. There are articles dealing with establishment, articles dealing with the right to provide legal services, and so on. So is it that you're saying that in enacting and operating Section 15(1)A of the LPA, Trinidad and Tobago discriminated against your client in relation to these rights?
Yes, that is what we are submitting.
But that's not what you're saying in your skeleton argument, because we can't find any place in the skeleton argument where that point is made. So where do we go from there?
Could you repeat the question, please?
Yes, if we can't find any link between your argument that Article 7 has been breached and the substantive rights in the treaty, within the scope of the treaty, that you say have been breached in consequence, then where do we go from there? Are you asking us to allow you to amend your skeleton argument? Do you think there's no need for you to amend the skeleton argument? I'm just trying to understand how you're going to make that nexus between arguing a breach of Article 7 and then not identifying the substantive rights that you say have been breached by Trinidad and Tobago.
Your Honor, I believe that the link we sought to make in our skeleton argument was that by way of breaching the agreement establishing the Council of Legal Education, which is a regional agreement, and thereby Trinidad and Tobago was under an obligation to fulfill this. By breaching this agreement, they subsequently breached Article 7. So that is the link we sought to make within our skeleton argument.
Mm-hmm.
But argue, Article 7, ma'am, speaks about within the scope of this treaty. And we have in cases, Cabral, Douglas, Ellis, Richards, I trust you will come to those, say that this is not a standalone provision. You must link it to a substantive right. So how do you bring in the CLE there?
We bring in the CLE here because Trinidad and Tobago enacted this piece of legislation which is contrary to the CLE. And if they did not breach the CLE, then there would be no breach of Article 7. Because in breaching the CLE, they've enacted legislation and subsequently excluded all other CARICOM nationals.
Suppose they would not have done that. Suppose they would have said, okay, this is open to every CARICOM national. Would that not still be a breach of the CLE agreement?
Yes, it would still be a breach of the Council of Legal Education Agreement, but it would not be a breach of Article 7 of the revised Treaty of Chaguaramas.
Correct. But you're saying, well, we're linking that discrimination, Article 7, to the CLE. So only in this particular case then, not just because it's a breach with the CLE agreement, but because, as you say, if it was open to all nationals, it would still be a breach of the CLE agreement. That's logic. So it doesn't seem to be very persuasive, at least prima facie.
We seek to submit that because of this CLE breach, which my junior counsel will further elaborate on, and its relevance to the breach of Article 7, that if the Council of Legal Education was not breached, then there would not be a breach of Article 7 of the Council of the Revised Treaty of Chagramas.
Now, I think the time is running, but you were mentioning Article 30, but I didn't see any submissions on that in your written submissions, correct?
Correct.
Yes, but it is a point. We know that although the state of Trinidad and Tobago is not present today, but we know that that is one of their arguments. So would have been better maybe that you would have dealt with it in your written submissions. But to keep it short, what is your answer to that possible defense?
We submit that to that particular defense that Trinidad and Tobago is making, that the scheme of legal education in the Caribbean does not fall within any of the 4 categories under Section 33.
And I do sympathize with the fact that you are in an awkward position because, you know, you did not get the defense of Trinidad and Tobago, and therefore you're not able to make a response under the rules that we have.
All rise for the Honorable Judges of the Caribbean Court of Justice.
You may sit. Yes, Ms. Dukran.
Yes, Your Honor.
Well, we are happy to see you sitting again.
Thank you.
And, well, you remember that sometimes we fall, but we stand up, and that's what you did. And I think you came in with an applause, and it's well deserved. Of course, we are very concerned, and we would like you to be able to, when you finish, to have you check up and so on. But we're happy that you recovered and that you have the strength, at least to want to finish your presentation, and that, you know, it's mental, and the mental element is very important. So we wish you Godspeed, and with your health, that everything will be all right. We give you the opportunity to finish your presentation from the bar table.
Thank you, Your Honor. So to continue where I would have left off, my final point would have been that community law should take precedence over domestic law. And this was emphasized by this very court in both cases of Shanique Myrie as well as Maurice Tomlinson. This court would have emphasized that states should have their internal laws in conformity with community law in order to prevent any breaches of international obligations. Article 27 of the VCLT also goes on to state that a state cannot use their internal law as justification to breach any treaty obligations. This would bring me to the end of my presentation, and if there's nothing else that I can help the court with, I will lead you to my co-counsel, who will be submitting that Trinidad and Tobago breached the agreement establishing the Council of Legal Education. Thank you, Your Honors.
Thank you very much, Mr.
Thank you.
Dukran. Is it that you want to take your leave now, or you want to wait till your co-counsel has spoken?
I'd like to wait, please.
Of course, we understand that fully, so that you may take your leave now. I think your father is here too. Yes.
Good,
As you want to leave?
Oh, she wants to-
Yes.
good morning. I am Dylan Kalu. junior counsel for the states of Grenada and St. Lucia. If it pleases the court, I would begin my submissions.
Sure.
Thank you. I would first like to outline to the court my arguments for submission here today. First, we will be submitting that Trinidad and Tobago has breached the Council of Legal Education Agreement and the principle of pacta sunt servanda. Second, I will be re-emphasizing on the point that my co-counsel brought up, that community law should take precedence over domestic law. And third, we will be submitting that the CCJ should have jurisdiction to adjudicate a breach to the Council of Legal Education. First, I will submit that the Council of Legal Education is the basis of the legal education in the CARICOM community. It forms the legal education scheme. What Trinidad and Tobago has done is enacted legislation, namely 15(1)A of the LPA, which co-counsel would have elaborated, breaches Article 5(1) of the Council of Legal Education Agreement, which states that the legal education certificate shall be the minimum requirement for admission to practice in the CARICOM region, to which Trinidad is a signatory. Further, this breaches the principle of pacta sunt servanda, which is seen in Article 26 of the VCLT, which basically states that principle and agreement must be kept. We see that this court holds this principle on a regional level. We see this in the case of Resumption Beverages against the state of Guyana, where Guyana would have enacted legislation that was directly in conflict with Article 80 of the RTC. This cannot be held to be this court stated that it cannot condone laws in a jurisdiction that is in conflict with its international obligations. And to draw reference to a case that my co-counsel would have elaborated on, which is the case of Maurice Thomason, we can see that state practice also plays into this as well. We would like to submit further that community law should have precedence over domestic law. If we draw our attention to quotes from one of the honorable judges sitting before us today, Justice Winston Anderson. One second. Yes, and as we look at this here, the community law and supranationality regional integration, the role of regional tribunals. This honorable judge would have talked about the tightrope that independent sovereign states wish to walk between asserting their individual sovereignty and at the same time recognizing the imperative that regional integration requires the effectiveness of community law. We are saying this is the issue at hand here. The revised Treaty of Chaguaramas and the Council of Legal Education are linked in this way. While under Article 10 of the revised Treaty of Chaguaramas, the Council of Legal Education is not an organ of the community, we are arguing that it is an integral part to the functioning of the community and should be held to be adjudicated by this court because of the fact that member states of the revised Treaty of Chaguaramas are also parties to the Council of Legal Education. And we further submit, if we look at the case of Rockhard Distributors Limited, we see that this court made the discussion whether the World Trade Organization laws were to be held as a part of community law. And we would like to contrast this here, that this Council of Legal Education Agreement is inextricably integral part of the community.
One of the differences, though, counsel, with the Hard Rock case is that the RTC itself made reference to the WTO.
Yes.
In several places, actually, as you know. Does the RTC make reference at all to the CLE agreement?
No, it does not. But we are arguing that whether or not it makes reference to it, we can also draw reference to the case of Doreen Johnson, where this court would have stated that even though they are not listed organs, we can draw a reference to paragraph 12 of the case here. Institutions and associate institutions of the community are not unlike specialized agencies of the United Nations. In this instance here, the Council of Legal Education is a specialized council of the community, and we submit that this court should be the one to adjudicate a breach to it, because this is limited to regional bodies signing this, regional states signing on to this Council of Legal Education agreement.
So how do you distinguish that proposition from holdings of this court, for example, in the Rein Johnson, where we held that Caricat could not be a defendant, or Jason Jones, where we held that the CLE could not be a defendant? How would you distinguish that line of cases from the argument you are trying to press on us now?
Thank you for the question. We understand that this court in Jason Jones against Council of Legal Education said that it would not condone having the Council of Legal Education as a defendant and could not direct the Council of Legal Education what to do. We are submitting that the court should not direct the Council of Legal Education what to do. We are submitting that the court should have jurisdiction to adjudicate breaches, simply breaches, to the Council of Legal Education, because we also recognize in the Council of Legal Education agreement that there is no article dealing with dispute settlement. And we seek to submit that this court should have the jurisdiction to adjudicate breaches.
So the mere fact that the CLE agreement doesn't have any dispute resolution provisions, you're saying that that in itself opens the door for us to be the dispute settlement mechanism for the CLE?
We are submitting because of the fact that this agreement is so integral to the functioning of the legal system in this region. Without it, the legal education scheme would collapse. We are saying that because of the importance of this agreement and the inextricable link it has with the revised Treaty of
Tell us
Chicago.
about that. What is that inextricability of the link between the CLE and the RTC?
We are saying that, apologies, the link I was referring to was that because Trinidad and Tobago breached Article 5.1 of the Council of Legal Education, they inextricably breached Article 7 of the revised Treaty of Chagramas. We are saying that this inextricable link here is what is allowing the court as well to have jurisdiction to adjudicate a breach to the CLE.
That is the point I don't understand, because as your lead counsel acknowledged, if the legislation of Trinidad and Tobago had said, well, this new avenue is open to all CARICOM nationals, not just TNT nationals, it would still be a breach of the CLE agreement. So not necessarily the breach of a CLE agreement constitutes discrimination. You are saying it's an inextricable link between this breach and Article 7 of the RTC, but maybe you could explain this a little further, because I have a difficulty in understanding the logic of that.
Yes. What I would like to submit is that whether or not Article 7 applied, whether or not there was discrimination, the CCJ should still have jurisdiction to adjudicate a breach, simply based on the fact that community law should take precedence over domestic law. And if we draw reference to the case of the Turks and Greek exchange, where in this case a convention was made between the Turks and Greeks stating that they would exchange nationals, they stated that their laws should be in conformity with the convention. And we recognize that Section 3 of the Council of Legal Education Act of Trinidad and Tobago also gives Article 5 the force of law in Trinidad and Tobago. We are saying that this is a further violation of Trinidad and Tobago breaching Pacta Sunt Servanda, and we would like to use this to explain to the court that they should have the jurisdiction to adjudicate a breach to the CLE because of the fact that it's so important to the region.
But
Thank you, Judge. Mr. Is it Kalu? Yes.
Yes.
I imagine Trinidad and Tobago, if they were here, would say that there was no breach, number one, and no discrimination, but they would also say that what they have done was justified, what could be called objective and reasonable justification, because they sought to ameliorate some sort of hardship that nationals of Trinidad and Tobago were experiencing in being able to access the law school or law schools. What do you say of that argument?
Thank you for the question. We recognized in a case that Trinidad would have adjudicated on, the case of Diane Hadid, they would have stated that the reason that Section 15.1a was created was for the fact that there is a need for lawyers, and the Hewitt Law School does not have the spaces required for this purpose to meet the demand of lawyers in the country. However, we submit that this argument is weak and invalid because what they want to do cannot breach their international obligations. It cannot breach an agreement that is held on a regional level. If they wish to amend the agreement, they need to bring it up with all the signatories to the agreement, as stated in Jason Jones and Council of Legal Education. Then they should have brought it up, not enact legislation that would be in direct conflict with the international obligations.
But part of the reason you're giving for that, part of the case for your client, is that the breach wasn't broad enough, because you're saying that your client ought to have been admitted under Section 15.1a. Are you not saying that?
Sorry, could you repeat?
Are you not saying that your client, Mrs. Khalid, ought to have been admitted to practice in Trinidad under Section 15.1a?
We submit that she does not have a legal education certificate and therefore would not be able to be admitted to practice, because what we are arguing here is that we are arguing for the furtherance of development of community law. We argue that the Council of Legal Education should take precedence, meaning she would eventually need to get a legal education certificate. Unfortunately, our arguments do not support her LPC to be admitted to any CARICOM nation or a member of the signatory of Council of Legal Education. But we argue that it's more important to argue for the furtherance of the development of community law.
Okay.
Yeah. Because of course, your client is the state of Grenada, I think.
Yes, she is.
And she is not. But of course, we were under the impression that maybe the state of Grenada was espousing a claim, but apparently you take an independent approach as a state and say, well, whatever her interests are, we think that there is a breach of the CLE, and that's why, because you also ask us to order the state of Trinidad and Tobago to repeal or amend the legislation to be in conformity with the agreement, the CLE agreement. That would mean that you would want us to order, we never gave an order like that, by the way, but we want the court to give an order to the state to put back that LEC requirement. Isn't that correct?
My apologies, in my skeleton, I did not clarify. The order was just a remedy that Trinidad could follow. We recognize that this court can only make a declaration that Trinidad and Tobago is in breach of the revised Treaty of Chaguaramas or the Council of Legal Education Agreement.
But what you want to achieve is that Trinidad would put the LEC requirement back.
This is
that what you?
Yes.
Okay, that's a different perspective.
Yes.
I wondered though, Mr. Kalu, can Mrs. Khalil practice in Grenada?
No. If we look, I see my time is running out. Would I be able to get additional time in order to answer this question?
Certainly, you go ahead.
Once we ask a question, we give you the opportunity to answer.
Okay, thank you. If we look at the case of Diane Hadid against the state of Grenada, which was a 2022 case, there was a similar issue where she was a Grenadian national, but she had an LPC. She was not admitted to practice, and the Grenadian LPA only allows for those who have been those who have been admitted to practice in legal systems that are so similar to Grenada to be admitted to practice in Grenada. So in this instance, she would not be allowed to be able to practice in Grenada or St. Lucia.
So somebody with a set of qualifications then, which are analogous, I think that's the word used in 17.2 in Grenada, to the legal system in Grenada, would be allowed to practice law in Grenada?
Yes.
Yes. Is that not a breach of Section 15.1 of the agreement, CLE?
I would argue that yes, it is a breach of Section Article 5 of the Council of Legal Education Agreement as well.
So you're here arguing that Trinidad and Tobago is breaching Article 5, but you're also admitting that your client is also breaching Article 5?
What this case stated that I'm referencing is that it is admitting those who practice who are already admitted in another region that have a similar legal system to Grenada.
Right.
And while we recognize that they don't have a legal education certificate, they need to go through stringent conditions that Grenada would set out.
But not stringent conditions that include those specified in Article 5 of the CLE.
Yes.
Yeah. So we get back to the point then that we can't adjudicate the issue, obviously, because your client is not a defendant in this case. But it suggests, does it not, that your client might be in a similar boat to Trinidad and Tobago?
Yes, we do recognize this.
Yes.
And we continue to hold the point that whether it be Trinidad and Tobago or any other state that is a signatory to the Council of Legal Education Agreement should in fact have their laws that are in conformity with the Council of Legal Education Agreement.
As a matter of interest, do you have any idea as to how many other countries in our region may be in a similar position to Grenada and Trinidad and Tobago?
Unfortunately, no, I'm not aware in any other.
Yes. But it's a fascinating question, isn't it?
It is.
It is, yes.
Because it would appear that Mrs. Khalil would have had no issue if she were born here.
Not at all.
Or if she got married here.
Definitely.
Yes. Okay, thank you, Counsel.
Thank you.
Thank you.
Thank you.
You want to conclude or?
Yes, I would like to conclude if possible.
Sure.
Great. What we would ask this court is that you will please make a declaration that Trinidad and Tobago is in breach of the revised Treaty of Chaguaramas and the Council of Legal Education. We submit that this court should make this declaration due to the fact that Trinidad and Tobago is seeking to dampen community law. And as with our arguments, community law should have precedence. That brings me to the end of my submissions. Thank you to the court for listening to our submissions from the states of Grenada and St. Lucia.
Thank you very much.
Thank you.
Thank you.
Well, as the defendant state is not present, that would conclude this session. As I've said in yesterday, we always enjoy very much the submissions of the students. We were very sorry that what happened with Ms. Dukuran, but we are confident that she will fully recover, and also that there is no shame if this happens. You will stand up as you did, and you continue on the path that you have started. And we're confident that with that mental inclination, you will get where you want to go. So once more, thank you, counsel, for your submissions. In this particular case, it won't be difficult to decide who won, because there's only one party here. But of course, in the broader scheme of things, we will suspend our final comments and decision till after we have heard the last session this afternoon, In that case, we will then give comments on on the performances of every team, and even add, there is one category, the best oral performer, so we will deal with that too. And then once we have decided which of the groups won their session, and then we will give over to the master of ceremonies. We will then gradually announce the winners.
Yes.
But in fact, what happens is that you are all winners anyway.
Yes, if I may, Chairman, I know that
Sure.
this may be a matter for the room where we deliberate,
Sure.
but I always thought that where we have a race and there's just one horse in the race, there can only be one winner. So,
Yes.
in relation to the moot that we just heard, I wonder if we're going to have that much of a difficulty deciding on the winner.
No.
Okay. Thank you, sir.
Good. Well, anyway, that is quite clear. So I think we will now rise, and we will then hear the case. The case, we will hear it at, what is it, 1 o'clock? 1 o'clock. So, Madam Registrar.
This court stands adjourned.